Hello friends, this is Dr. Shashi Agarwal. I welcome you all for the channel Shashi Agarwal Economics and Law classes. Today our subject is business law, which is relevant for the student of BBA and BCom students. So our topic is classification of various contracts, and the chapter name is the nature and the classification of the contract. Earlier, we have done the important question all contract their agreement, but all agreements they are not contract. Or we could say, what are the essentials of the valid contract? This topic is also very important for the longer question as well as for the shorter question. The question could be asked explain the classification of the contract, discuss the classification of the contract, what are the various types of the contract, what are the various kinds of the contract. If you find my video useful, please do like it, share it, and also subscribe my channel Shashi Agarwal Economics and Law Classes. So this is my app, Adusum app, which you could download from the Google Play Store. It provides free study material, free mock test to the student of Commerce, Economics and Management. It also offers structured courses like Business Law, Principles of Economics, and the Business Economics are also available. So here we could classify the contract on the basis of validity, on the basis of formation, on the basis of performance. First of all, we will understand the contract classified on the basis of validity. So here we are going to understand the valid contract, void contract, illegal agreement, voidable contract, and unenforceable contract. So first is valid contract. The agreement which is enforceable by law is called the valid contract. An agreement which is having all the essentials of a valid contract which are mentioned under section 10 is called the valid contract, like the capacity of the parties, lawful constitution, lawful objective, and the free consent, etc. Void contract, which is defined under section 2J, a contract when it was formed, it was legally enforceable, but later on it becomes void due to supervening impossibility of performance. The contract which was initially valid, but later on it becomes void, it may be due to the supervening impossibility of performance or maybe due to the change in the law. Like a contract to import goods from a foreign country, later due to war between the importing or exporting country, it may become void. Earlier it was valid. When there was a war, then the contract becomes void. So void contract means it becomes null and void later on and it does not have any legal effect. A void contract is without any legal effect. Legal effect means we cannot go to the court for the enforceability. When it was made, it is valid. It is valid when it is formed. Continue to remain valid till it ceases to be unenforceable. There may be some supervening impossibility. There may be some change in law. Because of supervening impossibility of performance, it becomes void due to the supervening impossibility of performance, maybe due to the change in law, maybe it becomes subsequent illegal. There was a contract between A and B for publishing the book of A. After few days, A dies. It is void contract because now the A is dead and this contract is based on his personal skill. That is, he could write a book. And now he's dead, so it becomes void contract due to the impossibility of performance. In case of the void contract, it is not a contract at all. But for the purpose of identifying, it has to be called void contract. So the void contract is a that contract which earlier it was valid, but later on it becomes void. Contract on the basis of validity. Next is the void agreement. There's a difference between the void agreement and the void contract. Void contract is when it was formed, then it was valid. But the void agreement from the very beginning, it is void. It does not have any legal effect. The agreement which is not enforceable at law is said to be void under section 2G. It does not create any legal right or obligation. It is null and void from ab initio means from the very beginning. An agreement with minor is void. Agreement by person who are not competent to enter into contract, like minor, insane, lunatic, or we could say the person who are of unsound mind, the person who are disqualified by the law. Agreement which is made under a bilateral mistake of fact. Agreement with unlawful consideration and object are also void. Agreement without consideration are agreement which are declared to be void. Voidable contract. Voidable contract is valid, enforceable until it is cancelled by the party entitled to avoid it. The voidable contracts are those contracts where the free consent is missing. It is defined under section 2I. This happens when the consent of the party is not free. The party whose consent is not free, it is called the aggrieved party. That aggrieved party whose consent is not free may either cancel the contract or bound by it. A promise to sell his car for rupees 50,000 to B. The consent of A is obtained by force. Here the contract is voidable at the option of A. A is the aggrieved party, the whose consent is not free. So if A want this contract to be null, it could go to the court and the contract could be declared void. Voidable contract can be set aside, avoided at the option of the aggrieved party whose consent is not free. So it could be declared void at the instance of the party whose consent is not free, not at the other party who only that party could set aside or avoid whose consent is not free. Until it is set aside, it remains a valid contract until the action is taken by the aggrieved party. Once the aggrieved party avoid the contract will come to an end. If the aggrieved party suffered any loss because of the non-performance of such contract, he can claim compensation. If the aggrieved party has received any benefit from the other party, he is liable to restore such benefit. Illegal or unlawful contract. The word illegal means which is opposite to law. Here we are doing something which goes against the law. A contract is considered to be illegal or unlawful if the consideration or object which is prohibited by the law, or if it makes fraud to the others, if it involves an injury to the person or property of another, is immoral or imposed public policy. A lets if flat to be for gambling, knowing that it would be used for immoral purpose, the agreement is void from very beginning. So it is unlawful. Illegal agreements are one which violate the basic public policy, which are criminal in nature. Such an agreement is null and void. An illegal agreement they are void, but all void agreement or contract are not necessarily illegal. Illegal agreement may affect the collateral transaction which is subsidiary or incidental. Section 2G of the Indian contract, an agreement not enforceable by law is void, like unlawful object and consideration of the contract, illegality of the agreement which makes it void. Illegal agreement are void, but all void agreement are not illegal. Like the agreement with minor is legal, lawful, but it is void. It may not be illegal. Like here, A borrows rupees 20,000 from B, enters into contract with alien means the enemy country to import the prohibited goods. The transaction between A and B is collateral and illegal. When the agreement is illegal, it also affects the collateral transaction. Here, E borrows 20,000 from B. That is for the purpose of entering into import of prohibited goods. So it is collateral transaction. It also is void. Unenforceable contract which cannot be enforced in the court of law due to some technical defects, like they're not properly signed, they're not properly stamped, like in the sale of immovable goods that should be properly registered. An agreement which is required to be stamped will be unenforceable if it is not properly stamped. Now we will understand classification on the basis of formation, express contract, employed contracts, quasi contracts. E-contract and standardized contract. Express contracts are those contracts which are expressly agreed either by spoken or by written medium. Like A offers B that I want to sell by bicycle for rupees 1000. He spoke these words to B, so it is express contract. Or it could be in the written mode also, like A writes a letter to B that I want to sell my bicycle for rupees 1000. Section 9 of the Act provides that if the proposal or acceptance of any promise which is made in words, whether they are spoken or by written form, then it is said it is an express contract. Implied contract is one which is inferred from the act or conduct of the parties or the course of dealing between them. By implies means implied by law. Like you get into the bus, like you get into the bus, it means while you are sitting in the bus, your actions means that you have accepted the offer of the transportation. You have to pay for the fare. Like you takes a cup of the tea in the restaurant, it means you have to make the payment. So this is the implied contract, which could be inferred from the act or conduct of the parties. E-contract are one which is entered into between two parties by the internet. When a contract is formed by the use of electronic devices, it means it's a called e-contract, or we could it's a cyber contract, or we could say mouse click contracts. In electronic contract which are linked to other networks through electronic data interchange. Standard contract means like the business firm have to enter into large number of contract, due to which firm for the sake of convenience may use standard format of contract. It means they have already printed form of contract which is used by the insurance company, which is used by the hotel, which is used by the railway. Constructive or quasi contract, it is not a contract at all. Here the parties they do not want to enter into contract with each other, but the contract is created by the law. A contract which is not initially entered by intentionally entered sorry the contract which is not intentionally entered by the party, but the contract which is created by the law is called the constructive or quasi contract. It is a contract that exists by order of the court, like a trader who leaves his goods at B's house by mistake, and B treats the good as his own. He is legally bound to pay the amount. Here, it is the obligation of the finder of the lost good to find out the true owner and return the goods to the true owner. So here the intention, here the uh, like uh, here the contract is formed by the law. Constructive or quasi contract which are created neither by words spoken nor written, nor by the conduct of the parties, but these are created by the law. Tactic contract, which is implied contract, it means silent. Tactic contracts are those which could be inferred through the conduct of the parties without any words spoken or written. Like when cash is withdrawn from the automatic teller, that is the example of the tactic contract. Another example is assumed to have been entered when a sale is given effect to fall at the hammer of in auction sale. Like the hammer is struck at the table, it means the contract is complete. The contract has been entered into. Contract could be classified on the basis of performance, executed contract, executory contract, and executory contract is of two types, unilateral contract and bilateral contract. Executed contracts are those contracts which are executed. Both the parties they have performed their respective obligations, so nothing is left. Like A painted the picture of B and B paid the money. So it is an executed contract. Executory contract which is said to be performed. It is of two types: unilateral contract, in which one party has performed his obligation and the other party has to still fulfill his obligation. Like A painted the picture of B, but B has not yet paid. Bilateral contracts, in which both the parties they have to perform their obligation. Like A has to paint the picture of B and B has not made the payment of the picture. Classification of the contracts under English law. Formal contracts, they recognize them in England but not in India. Here, the consideration is not essential in such contract. These are of two types: contract of record and contract under seal. These are the judgment of the court. Recognition is a written, like the written acknowledgement of a debt due to the crown, that is a contract of record, which has been declared and adjudicated by the court having jurisdiction, or which is entered of record in obedience or in carrying out judgment of the court. A contract under sale which derives its binding from force from its form. It is written and signed, sealed, and delivered by the parties. No consideration is necessary. Contract under seal, contract made by the companies, contract of lease relating to land for more than 3 years, contract relating to transfer of British ship or any share therein. Simple contract, all contract which are not made under contract under seal are simple contract. Simple contract is a contract which may be orally, may be in written form, rather than the contract made under seal. Valid consideration may be implied from the conduct of the parties.